Renting an apartment or house means entering into a legal relationship with your landlord that gives you far more rights than most tenants realize. These rights exist whether or not your lease mentions them, and in many cases, your landlord cannot legally take them away even if both of you sign an agreement saying otherwise. The foundation of tenant rights in the United States is the implied warranty of habitability, a legal doctrine that your rental unit must be fit for human habitation. This was established as a matter of federal common law by Javins v. First National Realty Corp. in 1970, and virtually every state has codified it into statute. This is legal education, not legal advice. Consult a licensed attorney for guidance on your specific situation. The implied warranty of habitability means your landlord must maintain the property in a livable condition throughout your tenancy. This includes functioning heating, working plumbing, no serious rodent or insect infestation, a structurally sound roof and walls, working smoke detectors in most jurisdictions, and protection from dangerous conditions. When your landlord fails to maintain habitability, you typically have several legal remedies. You may be able to withhold rent, but this must be done carefully and according to your state's specific procedures, or you risk eviction. You may be able to repair and deduct, hire someone to fix the problem and deduct the cost from rent, again subject to state limits. You can sue for damages. In severe cases, you may be able to break the lease without penalty through a doctrine called constructive eviction. Security deposits are a constant source of landlord-tenant disputes. Every state has specific rules about how landlords must handle your deposit. Typical requirements include keeping the deposit in a separate, dedicated bank account, providing you with an itemized list of any deductions after you move out, and returning the deposit within a set deadline, typically 14 to 30 days after you vacate, depending on the state. Landlords can only deduct for actual damages beyond normal wear and tear, and for unpaid rent. They cannot deduct for ordinary aging of the property, for example faded paint or worn carpet from normal use. If your landlord violates the security deposit rules, many states allow you to sue for double or even triple the withheld amount as a penalty. Your privacy rights as a tenant are stronger than many people realize. In most states, your landlord must give you advance written notice before entering your unit, typically 24 to 48 hours, except in genuine emergencies. This is true even though the landlord owns the property. Your lease may specify these terms, or state law may set the default rule. Landlords who repeatedly enter without notice may be violating your quiet enjoyment rights, which is a separate legal doctrine protecting your right to peaceful use and enjoyment of your rental. Emergency entry is allowed for things like burst pipes or fire, but a landlord cannot manufacture an emergency as a pretext for entry. Retaliatory eviction is illegal in every state. If you complain to your landlord about habitability conditions, contact a code enforcement agency, organize other tenants, or exercise any other legal right as a tenant, and your landlord responds by evicting you or raising your rent, that is retaliation and it is against the law. Most states presume retaliation if adverse action follows protected tenant activity within a certain time frame, typically 3 to 6 months. The Fair Housing Act prohibits landlords from discriminating based on race, color, religion, sex, national origin, familial status, and disability. Many states add additional protected categories. A landlord who refuses to rent to you or treats you differently based on any of these characteristics is violating federal law. Here is a practical overview of tenant rights every renter should know. Your landlord must maintain habitable conditions regardless of your lease language. They must return your security deposit on time with an itemized deduction list. They must give advance notice before entering. They cannot evict you for complaining about conditions. They cannot discriminate based on protected characteristics. Before you ever have a problem, read your lease carefully, document the condition of the unit when you move in with dated photographs, communicate with your landlord in writing whenever possible, and know the specific laws in your state because they vary significantly. Tenant rights organizations in most major cities can provide free information and sometimes free legal assistance. This is legal education only. Please consult a licensed attorney for advice on your situation.